Good evening. My name is Msiya Kindiano. I'm a partner at Bookbinder Business Law. I head the Dispute Resolution Department. This evening, I'm joined by my good friend, Catherine Piper of Piper Analytics, without which a significant part of my personal practice would not be possible. The topic of today is the general subject area of insolvency in Botswana, which, Catherine, you will agree with me, is very topical. It would be useful for us to kind of just go over highlights. We've worked together for a very long time on a lot of different projects, but just give highlights of what it is you do, how it is you help attorneys like myself, especially in the insolvency space.
So I work in both insolvency, corporate insolvency and corporate restructuring. And while I take appointments as a liquidator or in this part of the world, a judicial manager, I also, one of my focuses is actually working with law firms. And working with people like you is actually working with you in the lead up to say a petition to wind up a company on the practical implications of what is going to happen in liquidation. And that's quite new in Botswana.
Yes.
Historically, it has been, we focus very much on compulsory liquidation, so winding up by the courts, applications petitions that are made to the court to have a company placed into liquidation. We don't really use other mechanisms, although we have them in our legislation, such as voluntary liquidation. Most of our liquidation processes are done through the court.
Absolutely.
So they're, by definition, they're bought by petition by attorney firms such as yourself. And historically, we didn't actually involve insolvency practitioners in the legal process to place a company into liquidation.
Absolutely.
So what I'm trying to do is work with attorney firms to see when insolvency is or liquidation is the right solution.
Yes.
And when it's not, when you can use alternative mechanisms. Mm-hmm. Again, we're a relatively immature market, so they're not necessarily that well known, but whether you can do a scheme of compromise, in other parts of the world it would be called a scheme of arrangement,
yes.
Whether you can just do an informal negotiation with creditors, because obviously liquidation is a very drastic and should be really the final the final option, and it is working with people to make them aware of what actually happens in the liquidation
100%.
scenario, 100%. And how costly they can be. Mm-hmm. Liquidators here traditionally they go on an hourly rate. We don't charge by asset, so it's a costly thing to do.
It is.
Recoveries generally are poor. Anywhere in the world, they're generally poor. They're generally poor here. Mm-hmm. The dividend that is ultimately
You're talking
payable.
cents on the dollar, or in the case of Botswana, tebes on the pula.
Tebes on the pula.
Yeah.
Yes. So, but the cost of winding it up, you have to do certain statutory things as a liquidator. You have to have meetings of creditors. You have to investigate. So there are necessary costs to instruct an attorney firm to place a company into liquidation is an expensive thing. It is generally only done as a last resort.
Yes.
In my view, it's often done too late.
Yes.
So it makes
100%.
my job as a liquidator or assisting the liquidator very difficult, because there's nothing to save. There's no the assets have been dissipated. There's no going concern element to the business. That you're just sweeping up the mess.
Yes.
Whereas if you can do it early enough, there are options that
are potentially available.
That
is amazing. It's pretty much impossible to get that.
Yes.
I mean, you and I did KFC together.
Yes, we did.
And like what you've just been talking about, we worked pre-liquidation together. Yes. We were obviously engaged by the major creditor at the time, but that was an instance in which the company had a franchisor that was clearly a very important stakeholder. There was going concern elements to the company that needed you to, I seem to recall, have to deal with various stakeholders, including the media, to disabuse the general public of the fatality that is ordinarily associated to insolvency. I mean, talk a little bit about that.
So I think here, I can't speak anywhere else, but I think here there are almost broadly two types of liquidators. There are those liquidators who come in to sort of shut things down, and it's a relatively quick process, and your disposal of the assets relatively quickly. My firm and the liquidators that I've worked with and myself don't view it like that, where our primary objective obviously is to maximize the amount to creditors. Yes. And that will sometimes include trading. So KFC was an interesting one because they engaged who they wanted to nominate in the petition to be the liquidator. They asked the question, will you trade? I mean, it's KFC.
Yes.
Obviously for KFC globally, they didn't want to see it going into liquidation. They didn't want to lose the footprint here. And we agreed. And we said, yes, we will trade in liquidation. And we actually, bizarrely, we opened stores.
I recall.
We were in liquidation. They were in the process, but we actually went through with it.
Yes.
But one of the things that we did was, as you say, we engaged. We were very clear on our media strategy to sort of say, yes, it's in liquidation. The general public doesn't really have an understanding of what that means, but it's not going to affect your fried chicken.
Indeed. And more importantly, suppliers, I think, who were obviously in no small amount of distress on account of that development.
Yes. In this instance, we obviously had some very unhappy suppliers and landlords, but one of the advantages of trading is that we could say, but these contracts are continuous. Yes. So, we're keeping the store, we're still buying the lettuce and, the chicken and KFC's magic spice, which they don't tell you, by the way. They that is a trade secret.
You didn't find out?
I didn't find out what the KFC spice is. So yes, and again, that was relatively successful. We went through a disposal process. We sold the stores as a going concern, the assets out of the company, and just continued with the winding up. And Botswana still has KFC.
Absolutely. Franchisor was happy.
Yes.
Someone else is the franchisee.
Yes. The buyer entered into a franchise agreement with the franchisor, and they continued. We did what we do, which is pay the creditors with the amount that we realized from the assets.
Yeah. But what I want to jump into is what you kind of mentioned a little bit earlier about the different options that ought to be available or ought to be considered by a company in this kind of state, alternatively by creditors that are looking at a company in this kind of state. So let's talk specifically about judicial management. As structured in our law.
Yes.
What works, what doesn't work, and why, in my view, it should be avoided it should be avoided completely. It should never be tried.
Judicial management here, I think, has historically been quite unsuccessful.
Absolutely.
Part of the reason for that is the provisions in our law that judicial management should, if an application is made for liquidation of a company, judicial management should be considered as an alternative.
Yes.
And what has happened is really fatally insolvent companies have been placed in judicial management, and they've been placed in judicial management as a sort of liquidation light,
Yeah.
really.
Yeah. I love that phrase. Yeah,
judicial
absolutely.
management really, a company should enter judicial management when it has a plan to be able to trade out of its insolvent circumstances.
Alternatively, whatever circumstances are resulting in its distress.
Yes.
Could be mismanagement.
Yes, it could be. So
deadlock.
You've
whatever. Yes.
resolved that issue.
Yes.
And very often the court will place a company into judicial management, and there is no plan either to trade back to insolvency or to address mismanagement. So the company just effectively treads water insolvently for a while, and then ultimately just goes into liquidation.
Yes.
Anyway.
Yes.
Trading an insolvent company is a particular ask. It's obviously quite risky.
Yes.
Which is why a lot of liquidators will often not consider it. They'll, as I say, they'll just sell the asset.
So, and for that reason, I think it is unsuccessful because the company has no ability to be able to trade out. And it's just really a delaying process. And companies sit in judicial management for years. We don't have a limit on how long a company can be in judicial management.
That's true.
Other comparable regimes elsewhere, they normally limit it 3 months, a year it has to be revisited. Here we don't, and you can have companies in judicial management for years and years, and the judicial management isn't trading out and isn't making an application to wind up the company.
And it's just practically, legally, functionally insolvent during this period. What I would want you to do, though, for purposes of our audience, is put liquidation light on one side, judicial management, and compulsory liquidation on the other side, and tell me the pros and cons of each, if you can.
I can try.
Yeah, I mean, at a very high level. But I think what we're about to go into is going to highlight for our audience exactly what we're talking about, but in practical effect. So I'll give you a very, very simple example that I can think of off the top of my head. Interest, right? In compulsory liquidation, it stops running.
Yes.
Right? You don't have that. I'm not quite certain, but I think I'm right in voluntary winding up or in judicial management.
I think one of the misunderstandings here, somewhat surprisingly, is in judicial management, it's a technical term, but a concursus of creditors isn't created at the time of the liquidation of the judicial management order.
Concursus, for those who are not Latin speaking, is the general body of creditors.
The general body of creditors.
Yes.
So in theory, in judicial management, creditors the expectation is they're going to be paid, in the ordinary course because the company is continuing to trade. You can have a provision where the creditors in the post-judicial management period are paid in preference to the others, but it doesn't. There isn't a concursus that is created.
Correct.
In a liquidation, what happens when the provisional order is granted is you create a concursus, and it's like a shutter comes down, and there are certain kind of key things that happen. One is that interest stops to run. So there are other advantages, in my view, to a company entering provisional liquidation, and one is you have an automatic moratorium on people being able to take legal action against the company.
Or execution.
Yes.
Section 376.
Yeah.
Yes.
So that happens automatically. You can have it in judicial management, but you have to seek it, and it has to be part of the court order.
And it is not peremptory. The court may grant that order.
Yes.
In appropriate circumstances. Yeah. And I think this ties back into what we were talking about earlier, which is that judicial management is not necessarily sought as a consequence of a company dealing with insolvency, but also mismanagement, deadlock, and so on and so forth. There's many reasons why a company could possibly be
so it doesn't
seeking,
necessarily
absolutely.
protection.
Yes.
So I did mention it earlier, but I think it's worth repeating, which is, the process in which we go through. Compulsory liquidation is much more common here. We very rarely do voluntary liquidation. We do have provisions. Yeah. Certainly, creditors' voluntary liquidations, very rare, very rare. One of our quirks in ours is you don't get an automatic moratorium, so they're very rarely considered. Certainly, lawyers very rarely recommend them. Members' voluntary liquidation when the company is solvent, we do a few, but so our main mechanism by which insolvent companies deal with their issues is compulsory winding up by the court. Yes. That's effectively what we use. And our process is a petition is made, we go into provisional liquidation, a provisional liquidator is appointed. We then have the final liquidation. So we have a waiting period, and then we go into final liquidation. The provisional liquidator basically carries through that period to the first meeting of creditors, reports at that meeting. The final liquidator is appointed at the first meeting of creditors. We have a second meeting. You can have more, but 2 are required. And then only after the second meeting can the liquidator sell the assets. So that's our process. And why I think provisional liquidation can be more effective than judicial management is, while there is the sharp intake of breath with a company going into liquidation, perhaps more so than judicial management, it affords a provisional liquidator the option to explore compromises, etc. So a judicial management can't propose a scheme of compromise.
No.
But a liquidator can.
Yes.
So the company has the option to compromise its debt and still come out of liquidation.
Yeah.
So it gives a flexibility. Obviously, interest stops running. You're protected from creditors. You can investigate. You can do a compromise. The company can be restored to solvency by virtue of the compromise and carry on. Whereas for judicial management, I'm involved with the matter at the moment, and there are options potentially for compromise, but what is influencing our decision is the fact that we have a significant amount of interest that we should be paying in judicial management, which is making it almost impossible for us to maneuver.
Right.
To be able to find a way out. Whereas if the company had gone into provisional liquidation, while it's I don't know that there would have been that much kind of PR fallout any more than judicial management, but it certainly would have given us breathing space.
And indeed, like you said, the PR fallout
with suppliers, all stakeholders, including the general public, can be managed, as was done in the case study that we discussed a bit earlier.
Yes, it can. You can
get ahead of it.
Yes, you can get ahead of it. And that's part of what a good liquidator or a good judicial manager should do, is obviously engage with your stakeholders in advance of whatever decision is going to be done while you're acting.
Yeah.
And sort of reassure the market.
100%. But I think we should leave that. I think we should leave the case study of BCL for our next installment. I think at this stage, I am going to give you an opportunity to give the last word.
But what I would like to give a plug for is this idea that we started at the beginning,
yes,
which perhaps for some is self-evident, but it is this idea of actually involving
an insolvency
practitioner when we're trying to resolve matters.
Yes.
Because I think it is beneficial ultimately to the creditors, to the company, to explore different options, not just legal options.
Correct.
I often say to people, you can be legally right, but half of nothing is still nothing.
Absolutely.
So, involving people that are practically have to implement, a liquidation scenario is it's worth understanding what the realities are of any kind of legal decisions.
Absolutely.
And I've worked very successfully with your firm, precisely because, while I'm not a lawyer, we come to an understanding where you accept that you this is the law, but this is practically how it shakes out.
Absolutely.
And we can kind of work together on that, and sometimes avoid sort of liquidations if possible. Yeah. I'm not a sole advocate of that, but it is finding a way to find a solution.
Yes.
That's both practical and legal.
I think that's where the firms that operate in a certain way separate themselves from the firms that don't. Like you said, you can be right. You can go to court. You can have a court order. Yes. But congratulations. So what?
So what?
Have you actually solved a problem? Have you actually resolved a situation for the creditors? Those are entirely different questions. And I think if there's anything that is really to be highlighted from our discussion, is that this collaborative effort is absolutely key to the success that we have both had, and hopefully will continue to have in this area as we continue to practice in the insolvency space here in Botswana.
Indeed. Indeed.
Catherine, I bid you a good evening.
Thank you very much. Thank you for inviting me. I've enjoyed it.
Good.